I'm delighted to introduce our today's speaker. Catherine Handley is the William Voss Bascom Professor of Law and Political Science at the University of Wisconsin-Madison, where she has taught since 1993. Her research, focusing on legal reform in post-Soviet Russia, has been supported by multiple grants and fellowships, including the National Science Foundation, National Council for Eurasian and East European Research, World Bank, and Fulbright Scholar Program. She has published widely on legal and economic reform in Russia and on issues relating how ordinary Russians experience law. Catherine teaches contracts as well as courses related to her interest in Russia, such as comparative law and Russian law. She holds a joint appointment in political science department where she regularly teaches Russian politics, law society and politics and comparative legal institutions. She has served as a consultant in the U.S. Agency for International Development and the World Bank in their work on legal reform on Russia. She received her PhD from University of California, Berkeley. We are lucky to have Catherine to give a talk here, and please join me in welcoming her.
Well, thanks very much. And what you've been looking at here to entertain you while you were waiting for us to get started are the pictures from my field work. And these are pictures of Justice of the Peace Courts, the outside of them, as well as the inside of them. And I know when I've presented them before, people that are not really that familiar with the setup of courts in Russia said that you really get that linoleum feeling from them. You know, it's a very different. The places where they're located are different. They're relatively new courts, as I'll talk about, and so they've had to be almost sandwiched in, sometimes to residential areas, sometimes to more commercial areas. And you can see that the furniture is not the kind of mahogany stuff that we're used to in our courts. And this plaque here speaks to the fact that all these numbers are different districts of Justice of the Peace Court. So sometimes they congregate them all in one place, which I'll talk about a little bit as well. But let me now switch over to the PowerPoint for this talk. Let's see here. So what I'm going to talk about today is a fairly big project that I've been working on for quite a long time that looks at the question of everyday law in Russia. And what I mean by that is I'm trying to look aside from the usual story that we hear about Russia, which is the story of politicized justice. And that's been very much on the front pages recently with the release of Khodorkovsky and of the women from Pussy Riot. And that is certainly a big part of the reality of Russian law. But what I'm going to argue is that that's not the whole story, and it's not the story that most people experience in Russia in terms of what law is all about. And I'm going to talk mostly today about courts and about the lowest level of courts, the Justice of the Peace Courts. So let me start just by putting out what is the common wisdom of what we think we know about courts in Russia. And Masha Gessen has also been much in the news lately because of the new book that she just has out on Pussy Riot. And she's extremely critical of the courts and is sometimes even compared what's going on in Russian courts today to the 1930s, which seems to me to be somewhat on the hyperbole side, but we can debate that. But we see here that she's expressing, I think, a sentiment that is not unique to her. This idea that Russian courts are, especially in the criminal area, which I'm going to talk less about than in the civil area, but this idea that they're not really engaged in justice. They're really are engaged in a more political kind of activity. And here we see this idea of trust in the courts, which I think is a tricky question. And last night we had a workshop for people that are more deeply interested in Russian law, and we were debating this question of the linkage between trust in courts and use of courts. But just to give us a sense of trust numbers, and these are data that some of us may be familiar with from the Levada Center, and they ask about a whole series of different institutions. And one of the problems here is that when you take a country like Russia that has two distinct hierarchies of courts plus a standalone constitutional court, and you ask, do you trust courts? It's unclear exactly what question people are answering when they respond to that. Having said that, it's still interesting to see how their response to that sort of question ranks in terms of other sorts of institutions. And we see here that even though the numbers are somewhat increasing, they are not stellar numbers for the courts, especially compared to the presidency or the church and even the FSB, which is sort of a bit discouraging. And so just for those of us who aren't that familiar with the Russian legal system, let me just put this up and talk for a minute. I mentioned that there are two unique hierarchies of courts, and those would be the courts of general jurisdiction and the arbitrage courts. And we're going to be talking today about the courts that are at the bottom of this courts of general jurisdiction hierarchy. And the jurisdictional rules here are that if you are a human being, or a physical person, then most of your cases would be handled, almost all of the cases that you would be involved with would be handled by the courts of general jurisdiction. So this would be all criminal cases, all labor cases. This is the workhorse of the system. The arbitrage courts are basically a commercial court, and if you are a legal entity, then your cases are handled within the arbitrage courts. And so it's a more specialized court. It has it's a relatively new court as well. It's a post-Soviet court, and has developed a very, very impressive reputation, especially in comparison to the courts of general jurisdiction. For most of the 90s, my research focused on these arbitrage courts. I spent a lot of time in economic enterprises as well, and only in the past few years have I started working in the courts of general jurisdiction, and more specifically in the justice of the peace courts. And unlike many European countries in the post-war era, Russia has introduced a constitutional court. This first was introduced as an idea in the Gorbachev period and then came to fruition in the Yeltsin period. So that gives you a sense of the institutional framework. So let me talk for just a minute or two about the project itself and then explain what I'm going to be talking about today. So the project involves a couple of different methodologies and very much a mixed method kind of approach. So I did a whole series of focus groups 5 or 6 years ago in 5 different parts of Russia, and they looked at issues of home repair and issues of personal injury. The idea being that I wanted to find problems that could be solved by using the law or going to court, or problems that didn't necessarily require going to court. And in the book, I have a chapter that looks at the response of Russians in the wake of automobile accidents, and then I pair that with a chapter that looks at how they handle water leaks in their apartments. And this is something that's already been published in Law and Social Inquiry. But within the socio-legal literature, the theoretical approaches tell us that there should be a very different sort of approach if you're dealing with someone you know as opposed to a stranger, and that's what I'm getting at in those chapters that come out of the focus groups. And that's not what we're going to be talking about today, though I'd be happy to talk about that in the Q&A. What I am going to be talking about today is this observational research that I did in the courts over the past few years. One of those was a Fulbright year that I spent in Russia, and spent much of that time sitting in courts, talking to judges in all of these different parts of Russia, and that's where the pictures come from as well. So I spent time simply sort of hanging out in the courts and watching how cases were handled, talking to judges, talking to parties, although that was more problematic than talking to judges. And then I also have some statistical data about the activities of Justice of the Peace Courts that I'll be presenting as we go through this. And then there'll be a chapter in the book that looks at questions of attitudes and sort of a legal consciousness exploration using statistical data, because I think that one of the things, I published a piece a few years ago looking at legal nihilism and sort of unpacking that very famous remark that Medvedev made at the start of his presidential campaign about how, nowhere in the world are people as nihilistic as in Russia. And I'm always puzzled by this obsession with the Russians have about being the best at being worst. But the Medvedev remark is a perfect example of that, and the data does not really bear him out. But again, that's a whole separate piece that we can come back to if we have questions. So let me, and then here's just kind of an overview of how the project in the book is laid out. So let me now turn to these Justice of the Peace Courts. So they are even newer than the arbitrage courts. So they were contemplated as part of a large project on judicial reform, and a law was passed in the post-Soviet period, and a law was passed in the waning years of the Yeltsin regime authorizing these courts, but it was really only under Putin in the 2000s that they began to be put into place. And this was not something where you can just turn on a switch and have hundreds, thousands of these courts, because they are, the idea is that you will have one of these Justice of the Peace courts for every basically 20,000 people in Russia. So you can do the math for yourself. That's a lot of courts. And Russia's a big country, and they spread out somewhat gradually, and it took several years for them to make their way sort of throughout all the oblasts of Russia. So their jurisdiction, they're part of the courts of general jurisdiction, which tells us that they're dealing with physical people rather than entities. Although it doesn't mean that if you're a physical person suing a legal entity, that's in the courts of general jurisdiction. It's when you have two legal entities that they would be in the arbitrage courts. So their jurisdiction, the idea of them was to take what they considered to be the sort of mundane cases and move those out of the realm of what the district courts were deciding, to give the district courts more time to deal with more complicated cases. And so the jurisdiction is criminal cases where the possible punishment is less than 3 years, civil cases of less than 50,000 rubles, and relatively simple family law matters, and almost all administrative cases. And for the legal folks in the room, the Russian view of administrative law and our view of administrative law are somewhat different. So some things that we would think of as not necessarily administrative fall into the administrative basket in Russia. There's been a fair amount of monkeying around with these jurisdictional parameters. They started out with the 100,000 rubles and then reduced it because they got too many cases going to the Justice of the Peace Courts, and they're selected like other Russian judges through these qualification commissions. And we can talk more about that if people have questions about that. And so here, I wanted to just, these are some of the pictures that we saw in the slideshow, but I wanted to make a few comments about these pictures just to draw a few things to your attention. One thing that I found fascinating, and this one up in the corner here is a Moscow court, and one of the things that I thought was very interesting here is the ramp, right? Russia is not a land of ramps, and you don't see very many, and you don't see them at all courts, but I thought it was fascinating at this court. At several courts, you see this, and so this speaks to accessibility kinds of issues. I mean, Russia certainly has a long way to go in terms of accommodations, and I learned this for myself when I went there once with a broken leg, and I came out of the plane at Sheremetyevo, and I think all this is now changed because they've made everything very glamorous for the Olympics. But if those of us that are older can remember that you used to, go around and you would have to go down these steps. And I said, so they got me out on a wheelchair, and we go over to the steps, and I said, "Where's the elevator?" And they said, "What elevator?" Right? So that was the accommodation story there. But so I have always taken a great interest in that. And then we see here the courtrooms, and courtrooms are something that perhaps you would assume are present, and that's not a good assumption in the Russian case. It depends on the funding that is available. In Moscow and St. Petersburg, for example, and Yekaterinburg as well, every Justice of the Peace has their own courtroom, and it looks pretty much like this, where you have a table for each side, you have a lectern where someone can speak, you have a place for the secretary, and then you have a place for the judge. But in many other places, so Pskov, Voronezh, smaller places, judges hear a lot of cases in their offices, right? And this is one of the things that made my research more complicated, because it's one thing to go into a court, which according to the Constitution is open, and sit there. I may get questions, but to show up in someone's office is a slightly trickier thing to do just from a who are you and what are you doing here point of view. But you can see that not a huge amount of money has been spent on outfitting these offices. The other thing I wanted to draw your attention to are these information boards, which is what's in the bottom corner here. And this is something that dates back to the Soviet period, this idea that you would have, kind of a place where you have information about the courts, samples of complaints, and this is something that persists in the present day, even though a lot of that same information is online. And this would also be the kind of waiting area. And then here up in the other corner, you see what I was mentioning to you before. So when you have these multiple numbers there, that means that you have multiple Justice of the Peace Courts housed in the same building. And this is something that is was not the goal when they started out. The goal was, we started out with this notion of Justice of the Peace Court for every 20,000 people, and so the idea was this sort of romantic notion that there would be, almost a kind of community court. In fact, there was a lot of debate about electing the judges, and there's still enough flexibility in the law to allow that if regions would want to. Nobody has yet opted for that. But the idea is that the court would be nestled in the community from which the cases were drawn, because jurisdiction is geographic. So a single justice of the peace hears any case within their jurisdiction that arises in their geographic region. But practical considerations intervened, and most of these were simply real estate prices. And the problem of finding space for courts, because of course there are security issues and other kinds of things. And so there's a certain efficiency that comes with being able to bring several courts together. You only need one set of guards. Maybe there's some benefit in terms of being able to compare experiences for the judges. The downside, of course, is the access issue, that if you're actually in the community, then maybe it's easier for people to get to the court. But life is full of compromises, I guess, and in Russia, just like anywhere else. And so here we see the same story in Ekaterinburg, and this picture closest to me here is just an example of the outside of a court that is literally in a residential neighborhood, so kind of in a courtyard, and then just sort of made my life more complicated, because it's sometimes very difficult to find these things. But once you find them, then it's sort of obvious where they were. And down in the bottom here, you see an example of a judge's office. So this is what the situation would be, and you would see this little desk that comes out here. That's where the parties would sit, and they would sit there together and basically work this out. So let's talk a little bit. I want to present this in a way of looking at the story of these courts from the view of the bench, and then from the view of litigants. And so one of the challenges for the judges themselves is simply the large number of cases. And I know for a lot of people whose view of Russian law comes from the kind of the Khodorkovsky narrative, it might be puzzling and even surprising to hear that the Russian courts have a problem with overcrowding, with too many cases, because the narrative that we tend to, the assumption from the story that we usually hear is, why would anybody go to a court that's so deeply corrupted? And the argument that I want to make is that Russians, like all people, are capable of compartmentalizing. And while they may all be on board with and believe and understand that there are a number of cases that are highly politicized and compromised, they don't necessarily assume that those same problems would attach to their cases. And keep in mind that these cases that we're talking about here in the Justice of the Peace Courts have relatively small stakes. So this also somewhat mutes the issue of corruption, because the stakes are simply not high enough to make it worth your while to engage in corruption. So we see here that the goal of the creation of these courts was to shift the burden of the great mass of cases, most of which are not terribly challenging to shift this mass to the justice of the peace courts. And I think there's no question that that goal has been achieved. And that's a remarkable institutional achievement, to take a new court and to basically populate it with most of the cases. So they hear about 75% of all civil cases, almost half of all criminal cases. That percentage is lower simply because of the jurisdictional restriction, and almost all administrative cases go through the Justice of the Peace Courts. And I'll show you some trajectories on this too. The other thing that makes it challenging for justices of the peace is that there's no tradition of settling cases in Russia. So that once you, and this is a little bit of a complicated story because like everyone, Russians are not keen to go to court. So there would be a lot perhaps of negotiating back and forth when a dispute arises. But then once the decision is made to go to court, then they rarely settle or stop the case before it goes to judgment, which is something that marks it as being unusual, especially compared to common law courts. And then the third thing I want to draw our attention to and come back to is this question of the attitude towards discretion among judges. They're not very keen on it. Right? They prefer documentary evidence to testimonial evidence. Right? You have to petition to bring in a witness. So a lot of the cases are resolved by everyone getting out their documents and reading together. And then the other thing that limits their willingness to kind of go out on a limb is their distaste for being reversed. And this has a very practical route to it because one of the ways that they are assessed is in terms of how they manage their docket. And this is judged in terms of whether or not they resolve cases within the time limits, which are relatively short, that they are given within the procedural codes. A lot of countries have these deadlines. Russia actually pays attention to them and creates percentages are given to every judge, and then they look at how often you're reversed, and they really do not like to be reversed. So they are extraordinarily risk averse in this way. So let's look a little bit at the trajectory here, just to give you a sense of what the story is. So here we see, just simply looking at the number of cases, and one of the reasons I like to use this slide is that a question that I often get before I included this slide, well, of course cases are increasing because of the oppressive nature of the regime. There are all these criminal cases. But we see that that is not what's driving this story. Criminal cases are not driving this story. Instead, what's driving this story are cases that are more optional for parties, civil cases, where someone has to make the choice. Maybe someone isn't there because they want to be, but at least one of the parties is there because they've chosen to be there. So we see here, looking from 1995, so very soon after the transition from the Soviet Union to Russia, almost up to the present day, we see this remarkable increase in the number of cases. And then I just wanted to, and these are Russian data, and what we're looking at here is the red is the district courts, and then the green are the Justice of the Peace Courts. And what this shows us is the evolution of the role of the Justice of the Peace Courts. And what we're seeing here as we, of course there's nothing because there were no courts in the 90s, but what we're seeing here as the green goes up is just the increasing number of the courts that are operational, right? And again, this was simply a question of resources and how do you get this organized. But what we see here, again, speaks to the institutional story of bringing in this new set of courts. And here we see it for criminal cases, and as you would expect, it looks quite different simply because so many criminal cases are not within the jurisdiction of the Justice of the Peace Courts, and administrative cases. And here we're thinking, in case you're wondering, like what kind of cases are we talking about here? Traffic cases, tax cases, other kinds of cases like this. And we see that there's, a relatively small number of these cases that would originate in the district courts. Now, remember our original hierarchy, and of course, any case that starts in the Justice of the Peace Court could end up in the district court on appeal, but we're talking here about what is the entry point point for these cases. And I spoke about the heavy workload. So let me just show you a little bit of data about that. So here we see the monthly workload for justices of the peace from a few years ago. And one of the things, and we talked a little bit about this last night, that's puzzling, and these are by the Putin-era divisions of Russia, these large okrugs. And the central division includes Moscow, and you would think, well, why would you have fewer cases in Moscow? And the reason is this shift from 100,000 to 50,000 rubles. And you just, the cost of living in Moscow, at least this is how it was explained to me, is sufficiently high that you get fewer cases that are of that small number. And it's funny, I looked at that and I said, well, why don't you just have a different rule for Moscow? And when I suggested that to a Russian judge, you would have thought, I had suggested, well, let's just fly to the moon, because there is this very clear idea that we have to have this standard approach across all of the parts of Russia. And there's certainly some value to that. So one of the questions you might ask is, well, how could anyone possibly handle over 200 cases a month? And this was the subject of our discussion last night, and I apologize to those that were present. But one of the tricks of the trade here is that they have a procedural tool that allows them to handle simple cases, cases that are considered not to have a big dispute at the heart of them, straightforward cases maybe, cases that many judges would describe as garbage cases, that these can be handled through a kind of judicial order rather than having to have a full hearing on the merits. And what's interesting here is you see this extraordinarily high percentage of cases, especially once we look into the Justice of the Peace Courts. And of course, Leningrad Oblast, which is where St. Petersburg is, that's just crazy bizarre. And the reason there, when you look into the data, is that they just have, for whatever reason, an extraordinarily high caseload of tax cases that they work through this procedure. So this helps us understand how a human being could manage this many cases, because these judicial orders, судебные приказы, are kind of rote instruments, and they can be they have to be supervised by judges, but can be handled. A lot of the work can be done by their staff. And the reason why these are considered to be good options is the third column, which looks at the number or the percentage of cases in which the decision to use this instrument is challenged. So if I am on the receiving end of one of these judicial orders, say, I haven't paid my credit card bill and I get a judicial order saying that now I owe this amount of money to the bank, and then you can bring in bailiffs and all kinds of things to get me to pay that, but I disagree with that. All I have to do is simply send a note to the court, no special requirements, just saying, I don't agree. Right? Everything screeches to a halt. We have a hearing on the merits. The whole rigmarole of the process starts again. And so what we see is that relatively few recipients of judicial orders do that. And I think that's an extraordinarily interesting question and deserves almost a whole separate research project. And sadly, the way that they collect the data does not allow you to probe very deeply based on just the statistical forms, which is where I got these data from. The other thing is just the question of settling. I mentioned that there's no practice of settling, and here we see some data that support that general conclusion. There are a couple of ways that you can settle. One is to actually engage in a settlement agreement, a mirovoye соглашение, and that's the third column. We see that that's extraordinarily rare. And you could also basically withdraw your case, right? And that would be the second column. So it's just not a very common thing to do. So what we see here is that the story from the judge's perspective is one of, just almost a kind of a endless never-ending obligation to resolve these cases. And so judges tend to be, very worried about keeping the process going. I don't think I've ever spoken to a judge that hasn't used the idea of a conveyor belt in terms of talking about this, and not in a positive way. I think that they are sad that they don't have more time to work with parties on some cases. So I wanted now to turn and look at these courts more from the litigant's perspective. And when I'm making these comments, I think we need to remember that all of these ideas of access are relative, and that no court has perfect access anywhere, and no one really enjoys. Well, I take that back. I think there are people that enjoy going to court. When I had the focus groups, I had this guy who. And it was the first focus group I did, and it was just amazing. And he was a pensioner, and he just really enjoyed going to court. And he had been to court like 15 times. And there was actually an article about him in Argumenti Facti, where he talked about his whole deal in going to court. So I think, just like here, there are people that enjoy this. And one of the things that was fascinating about that focus group is then he kind of became like the guru of the focus group, because people would say, "Oh, but this is not possible," and he would say, "Oh, let me tell you, folks, yes, it is possible." So it was just, it was wonderful. So anyway, most people don't like going to court, whether you're in Russia or the United States or really any country in the world. But one of the things I think that is not really understood about Russia is that there is a strong institutional commitment within the judicial bureaucracy to easy access. And the very creation of these justices of the peace courts would be an illustration of that commitment. They are committed to keeping filing fees relatively low. For a significant number of categories, there are no filing fees. They have, as I've already mentioned, relatively rapid turnaround times. And here we're talking about weeks or months in terms of the deadline by which you have to resolve a case. And this is something where we have to remember the nature of the Russian mail. I don't know that there are that many people in Russia that even rely on the mail anymore. And certainly when you go into any apartment building, when you look at the state of the mailboxes, you would understand why people don't rely on the mail. But the courts do. And this is actually a difference between the arbitrage courts and the courts of general jurisdiction. The arbitrage courts, much like courts in Western countries, have increasingly moved to electronic filing, electronic notice. The courts of general jurisdiction are fighting that, and interestingly enough, when I would talk to them about that, it's another one of these things where are you crazy? How could we possibly do that? And I think what we have to remember is the very different audiences, the very different set of potential litigants that they're serving. Arbitrage courts are serving relatively sophisticated parties, people who are entrepreneurs or businesses, and the courts of general jurisdiction, and especially the justice of the peace courts, are serving the people who maybe aren't very computer literate and aren't able to handle email. A lot of elderly people and that sort of thing. But the point here is that just getting the notice to the person and getting a return postcard saying that the notice was received, that takes a couple weeks, right? So if you only have 2 months, then you start to see why judges are somewhat controlling about how they ask for, they don't leave it to the parties as to whether or not, as to what sort of evidence they're supposed to show up with. So it's relatively quick, and there's a lot of pressure associated with it because of the uncertainties of the mail. And as I already noted in the pictures, they have a lot of information with sample complaints and that sort of stuff at the courthouse and on the web for people that use that. And the information about law and about filing complaints is not limited to the websites of courts. It's, for anybody who's done any sort of search, that there's just tons of information. Now, the usefulness and the quality of that information can vary widely, but that's not unique to Russia. Also, the procedural rules are relatively straightforward. Especially, for someone that comes out of the Federal Rules of Civil Procedure in the United States. It's just, and in that way, it's more, Russia is not unique. It's much like many other continental European countries. The other thing we can say about justice of the peace courts, at least in the observations that I made, is that their lawyers are more the exception than the rule, which takes us back to the question of straightforward procedural rules. And this to me was intriguing, because one of the things that one hears constantly, whether it was through focus groups or just in anecdotal conversations with friends, is this idea that legal literacy in Russia is extraordinarily low, right? And yet people were figuring out how to do this. So one of the things we want to talk about here is the question of whether or not people are obsessed with the results that they get, or whether the participation, they're able to see that the court is, even if they don't rule in their favor, the court is still performing a useful function. This is something that comes out of, say, the work of Tom Tyler in terms of procedural justice, thinking that you can lose but still respect the institution. And we were talking last night about how there's the data tend to show that people who have used the courts in Russia have a higher opinion of them than people who haven't used the courts. And that's not a finding that's unique to Russia. That also is something that we found in the data on the United States. So I wanted to just show you a little bit about the websites from some screenshots and stuff. So the best websites for Justice of the Peace courts, and they vary because each region got to pick their own vendor to do them, and some regions, not surprisingly, not all the money that was supposed to go to those vendors ended up with those vendors. In Moscow, for who knows why, things went well, and so this is the portal of entry for the Justice of the Peace courts, and what you see here is a map of Moscow with the different colors being different subregions of Moscow, and then each one of these links being a further subunit, right? And then when you get down to a court level, this is what you would see, right? And this gives you a lot of information about the court. It gives you the name of the judge, their email. It gives you the phone number. I think it's very nice that they have a calculator to determine the filing fees. There are a lot of user-friendly options on these websites that I don't want to make it seem like this would be true of every website, but in Moscow this is true. And we can see here that you can search for the schedule, you can search for the text of opinions, and this is something that has been sort of a major change in terms of the text of these opinions being available. Russia, of course, as a civil law country, doesn't have precedent, but you're beginning to see parties coming in and studying the approach of the judge that they are in front of, to understand how she approaches things. And different judges take different positions when someone brings in a prior opinion to say, but this is how either you ruled on a similar case or someone else ruled on a similar case. Sometimes they will lecture them about how they don't have precedent. Sometimes they will, basically just say, well, that's very interesting, and we'll stick it in the file. And then here we see an example of the schedule. So you can go on there and see what cases are scheduled to be heard. This was very useful to me when I was doing the research, so I could see what was on the agenda. Not the greatest search engine in the world, but at least a starting point. And then here we see exactly what it looks like when you're trying to find an opinion. And this is a place where the search engine is particularly clunky, because most people, when you're looking for an opinion, you want to search by subject matter rather than by the name of the party or the number of the case. That's not something that the ordinary person would know. In thinking largely about the role of these courts, one of the issues that they have, and that affects, I think, both the justices of the peace and the parties as they are experiencing the courts, is this problem of the need for speed, right? This obsession with getting things done by the deadlines that are in the procedural codes. And the entire system, it's really not the kind of judgeships that we think of. It's more of a civil service bureaucracy, and has tools for assessment that are set up in that sort of way. And then this idea of reversals as mistakes, right? And so this creates a disincentive to perhaps get rid of weak cases and to allow people to multiple chances to kind of bolster their case, because they're don't do that, they'll be reversed. And then it goes to our question of discretion. I think reinforces the already existing tendencies within the system to be quite focused on the formal side of things and not to be so interested in what was really going on. I think I'll leave the question of telephone law for Q&A, and we can come back to that. I wanted to just give us a couple of examples of cases and use these to illustrate the issue of discretion. And I picked the category of what are known as private prosecutions or частное обвинение because this is the category of cases that justices of the peace hate the most. Right? And why do they hate them the most? Because this is a very bizarre little corner of law in Russia where you have a case that really is a criminal case, but it's not serious enough that the police want to have any part of it. Right? So basically what they're saying is that, so you're in a communal kitchen and someone hits you on the head with a frying pan. Maybe the police aren't interested in that, but you could take on the role of being kind of the prosecutor and go after the person that hit you on the head. Now, why do judges hate them? They hate them because there's nobody to gather all the evidence. In a criminal case, that's the job of the investigator and the prosecution. But here, the judges are sort of expected to serve this role. And remember our need for speed. They want no parts of this, right? So here's so these are, I have a couple of these in addition to these two, but, so a lot of these involve family situations. So here we see a mother-in-law and who feels like and they're living in these cramped quarters, which all of us who've been to Russia know how common that is. And so what often happens in these cases, and happened in this one in Yekaterinburg, is that in family situations, the complainant will be convinced by other family members and sometimes by the judge to withdraw the complaint, right? And what would be the reasons for that? Well, the judge loves to have these complaints withdrawn because then it goes off their desk. It's off their radar screen, right? And a lot of times this is the one place where judges get fairly actively involved in almost a mediator kind of role to try to bring the parties together. And one of the things that they will often remind the parties of is that if the daughter-in-law ends up being convicted of this battery offense, then all of a sudden she has a criminal conviction, and maybe that's going to limit the opportunities of her children to, well, for example, they couldn't be a judge in that case, and to have other kinds of jobs within the state service. So here we see judges exercising some discretion, and I think we see dual purposes there. They're trying, I think they would tell themselves that they're trying to help out the family, trying to save the family grief in the end, but also they're trying to keep their docket moving, right? Another great example of this I saw in Pskov, and this is not within people that knew each other. This is something where someone skipped out on a taxi fare, and they and I think maybe there was some hitting involved. Yes, he hits him. And so what happened is that as soon as this hearing started, rather than going through the usual thing, and usually in Russia the hearings start by everybody identifying themselves and everybody gets to tell their story, and then we see where we can go from there. Here we identified ourselves, and then the judge immediately said to the taxi driver, what is it going to take for you to let this go? Right? So rather than letting people tell their stories and getting involved in it and getting emotional about it, he wanted to nip this in the bud and just say, let's just get rid of this, right? And so what happens is the taxi driver gives a number, the other guy doesn't have that much money on him, we adjourn for an hour, the guy goes and gets the money, we hold his passport, and then everything is fine, right? So this would be an example also of discretion, right? But one where the goal is both to satisfy what he sees as a legitimate demand by the taxi driver, but also, again, to get it off his docket, right? A couple of other examples, moving away from the частное обвинение here, two examples where in the Petrozavodsk case, this was just horrible to be watching. Judges who have large shopping centers in their districts have a lot of cases like this, where older people will be bored and spend their days in grocery stores and do a little bit of shoplifting. And so here is a woman, and this woman came in, like her glasses were held together by string. She had 1 million plastic bags. We've all seen this woman, right? And so she tells her story. She's weeping as she's telling her story. She's, grabbing through these bags, trying to find receipts. The judge can't shut her up, can't get things back on track. And so eventually the judge just realizes, and the amount involved is, I can't remember whether I put it down here, like 84 rubles, right? So it's an absurd amount of money, and it turned out she had paid for some stuff and not paid for this, and maybe there was a cucumber in the pocket. Who knows what the story was, right? The judge just says, basically, let's call it quits. And it still took her like 40 minutes to get the woman out of the room, right? And why was she willing to do this? I think she had a lot of cases with this supermarket and understood what kinds of cases and the supermarket representative didn't show up at all, which would indicate that maybe they're not that invested in this particular case. And so she realized that there was not a risk here of having this appealed and a possible reversal. Exact opposite case in this Yekaterinburg case, where a woman came in. This woman was an accountant. She was getting divorced, or she was divorced, and she was seeking to go after higher child support from the ex-husband. And I saw a lot of these cases, and where upon getting divorced, the husband would immediately lose his job and take a job off the books. And so his formal salary was almost nothing. And so the percentage, I can't remember, maybe it's 25%, is that right, Katya, that you automatically have to pay, for one kid. But if you can prove that that is inadequate, but that's an affirmative obligation on the part of the petitioning ex-spouse, then you can get more than that, right? So she comes in, and she was an accountant. She had all her not very much different from the Petrozavodsk woman, where she had all of this information. She was able to show that the husband and the new wife and the new child were going off on lavish vacations where they were spending more in a weekend than the husband was supposedly making in a month. And the judge was extraordinarily sympathetic to this. But her position is I had a case like this 2 months ago. And she didn't say this to the woman. She said this to me afterwards. She said, I had a case like this a couple months ago where I sided with the woman because I could see that what was really going on here. But I didn't have, sort of the smoking gun. And the smoking gun here would be like a tax document or something like that, which the husband was doing everything he could to make sure that the ex-spouse couldn't get. And I was reversed. Right? She pulls off of her shelf her big binder, not too big, but the binder where she keeps all of her decisions where she's been reversed. And she goes, so I can't do it again. I have to do this exactly by the book. And so here we see an example where even though the judge clearly wanted to go kind of with the justice side of things, to side with this woman who clearly was being screwed by her ex-husband, she just was unwilling to do it because of the risk of being reversed and the implications for her of that risk. So the thing that I came away from in terms of hanging out with these judges is just the extraordinarily risk-averse nature of that they attitude that they have. And just as a final thing, I wanted to talk a little bit about how litigants experience the courts. And I said that, my ability to talk to them was somewhat limited. And of course, the question about how do you feel about something when it happens is maybe not the moment to ask. And so I was fortunate in being able to stumble over someone who had done a survey of folks who had gone to Justice of the Peace Courts and in these 3 different regions of Nizhny Novgorod, Rostov, and St. Petersburg, and had asked the parties what they thought of their experiences there. And of course, not a representative sample, lots and lots of problems with it, but at least a little bit of a window into what they're thinking. And here we see just a few descriptive statistics. We see that people were generally satisfied with the the competence of their judges, which goes against some of the common wisdom about what people think of judges. A lot of them thought that they were deciding on the basis of law rather than a telephone law type of thing. But again, keep in mind that we are talking here about very, very low stakes situations. And then about half thought that the judge had been completely independent, and another quarter mostly independent. And only 10% thought they had been totally biased. And I think most of us, in terms of what our common wisdom of, would think that it would almost be the reverse, right? And here I just did a, how successful was your experience? I think that for most of us who've done work on courts, we see that this is relatively high numbers in terms of thinking how successful you thought the experience was. And then I did a kind of a very limited regression here just because of the nature of the data in terms of looking at what factors contribute to feelings of success in the justice of the peace courts. And the gender issue is something that comes out in a lot of literature, that women tend to be more positive towards courts than others. But what's interesting here is that we see here that people who are prepared to go to court in the future are more positive about their experience, and people who have plans to appeal the decision less positive. And of course, people who were skeptical of the even-handedness much more skeptical. But at least a little bit of a window onto this, right? I mean, it would be great if we had more data, but I think all of us know the problem of trying to get information about what people who use courts think about courts. So in terms of conclusions, I think that, and this is something we talked about a lot last night, this question of the overwork of judges and of justices of the peace, and how they complain about it incessantly. And they almost never talk about the tools that they have that take almost, a significant percentage of cases off their plate, either almost completely, as with the judicial orders, or with in criminal cases, there's a version of plea bargaining that spares them from the full version of a trial on the merits, and that because this doesn't really fit in with this notion of judges as being terribly, terribly overworked, and so we don't talk about it so much. But there's no question that they are under a tremendous amount of pressure, and that even if we accept out all of these cases that are resolved in this more expedited way, it's still a lot of cases that they're having to handle in a relatively quick way. And so the other thing that I think is interesting is the data that we have suggests that a significant number of people who use these courts come away relatively satisfied with them. So it's I'm hoping what I'm saying here is not that the courts are perfect. I'm certainly, no court is perfect, but that maybe they're not as bad as we've been led to believe, and that maybe there are a fair number of cases that they're handling that are decided, according to the law. And the vision of the legal system that I'm trying to suggest here is one that maybe applies to all systems to some extent, but that in a way it's almost a dual system, a system where when you have certain kinds of cases, you expect them to be politicized, and you have that number of cases is unknown, but is relatively small, and that the vast majority of cases are handled in a way that is what we would think of as normal. And by that I mean that you read the law, you look at what the legal merits are, and that it comes out in that way. And that it's certainly possible that having a better lawyer could help you. I think that's less likely in Russia than perhaps in the United States. But the point here is that the dividing line between those two systems can be somewhat murky. And in this way, with this dual legal system argument, there's a persistence from the Soviet period through the Yeltsin period through the contemporary period. And the question of whether or not the universe of politicized cases is increasing at the expense of the mundane cases, I think that's something that we can only have very general impressions of, and it's very hard to know exactly what percentage each category comprises.